review of the legislation.
Mr Chair.
David Seymour, I think, after.
Mr Chair, I thank the member who just resumed her seat for setting a new standard in the scope of this debate, which of course I won't seek to reach because I respect your rulings, Mr Chair. So here, I wanted to touch...
mislead the House.
Mr Chair, I wanted to touch on the supplementary order paper because as I was working towards in my speech, it is an important part of the story of how this bill got there, and it has been helpfully alluded to by the member who just resumed her seat, that the Part 4 in this particular bill does actually change, or sorry, Section 4 does actually, Clause 4 does significantly change the role of undersecretaries, and once you are prepared to open up that distinction, then I think it is worth asking, is this the right way to do it? This House has limited time, there's limited resources for transferring information within government, and how do we find the optimal level of transparency across government, given those constraints? And it seems to me, Mr Chair, that the Law Commission did in fact make a very, very helpful contribution in its 2012 report on the public's right to know, when it advocated not only that the Official Information Act would be extended as it has been in Clause 4 of this bill, but actually extended much, much wider than that. And of course, the principles on which they drew in making those recommendations are the same principles as Clause 4 on this bill purports to be based upon. Mr Chair, it recommended, for instance, that the Office of the Ombudsman should also have the Official Information Act extended to it. And I support that, Mr Chair, and I'll mention in passing a supplementary order paper which has been ruled out of order, which actually would have made that change. But also, Mr Chair, the Law Commission, showing that it shows neither fear nor favour for its own profession, recommended that the judiciary have the Official Information Act applied to it. Mr Chair.
Right. Do I need to tell a member?
No, got the message.
Right, well, the member will now come back to the bill.
Thank you, Mr Chair. So, Mr Chair, as we can see, there's a theme here that by excluding a number of other possibilities, this bill has been very narrow in scope. But Mr Chair, it also tells us something about the motivations of the member in charge, and I think the people at home will often judge politicians by their motivations, and they might wonder why Mr Rarafe has brought any of these 4 clauses, including Clause 4, to this committee. Mr Chair, the fact that they've been so unwilling to follow the Law Commission's very sensible recommendations and included only undersecretaries in Clause 4 is one of the reasons I find it so difficult to support Clause 4. And I think people at home will be wondering why didn't Adrian Rarafe, if he was really committed to the public's right to know, why did he draft a clause that was so limited in its scope when other credible sources say that there are so many other aspects of government that might have been included in that clause? Mr Chair, that's why I find it so difficult to support Clause 4 and why people at home might be wondering why Mr Rarafe drafted such a narrow clause. And perhaps, if we're very lucky, Mr Rarafe will actually stand up and give the committee his explanation of precisely why that is. Mr Chair, I think it actually is worth mentioning that in several occasions in the recent past, a member has left this Parliament because of prosecutions brought in the court system, presided over by the judiciary, where they were ultimately exonerated in court, but nonetheless lost their career. And I think that if we are prepared in Clause 4 to extend the Official Information Acts to under-secretaries, and if the judiciary has also been seen to have so much influence on the proceedings in this House and actually change the balance of the House at different times. Mr Chair.
Paul
Hard
Foster
call.
Bill.
All right, more to come.
Thank